ਸਤਿ ਸ੍ਰੀ ਅਕਾਲ ਜੀ, ਮੈਂ ਮਨਜੀਤ ਬਹਾਦਰ ਸਿੰਘ ਬੋਲ ਰਿਹਾ ਜਸ ਪੰਜਾਬੀ ਤੋਂ। ਮੇਰੇ ਸਾਹਮਣੇ कैरी ब्रेड्स एंड कोवन तो प्रोमीनेंट अटॉर्नीज कैरी ब्रेड्स और एलिन ब्रेड्स बैठे ने तो वो जड़े कंप्लीकेटेड इमीग्रेशन दे इशूज़ ने जड़े लोगों के सामने आते हैं उन्होंने डील करते हैं तो मैं उन्होंने सामने कई क्वेश्चन रखांगा जड़े तुहाडे कई मसले ने इमीग्रेशन के उन्होंने वो जवाब देंगे। Mr. Kerry, you do mostly complicated immigration matters, and what are those matters that you deal with?
That's correct. It's mostly complicated. I would like, in fact, to have some easy cases. It would be okay sometimes. But mostly what I do are deportation defense, where there might be a criminal history or a previous immigration history with fraud, or a person needs some kind of waiver or combination of waivers. So very often the referrals we get in our office come from other immigration lawyers who feel that we're more equipped to handle those kind of complicated cases.
If a person is here in USA for the last 20 years and he married once and then he divorced and then he had a wife in India but he never divorced her and he marries a third wife and then after third wife he realizes that he has not divorced his first wife and marries the third, can it succeed?
It is possible, and while that scenario sounds unusual and complicated, it's certainly not unusual, and we see that in our office all the time. The key, first of all, if you get married and you are already married, under the law, that second marriage is what we call void ab initio. It doesn't count. So the key is to often go back and correct that second or that first marriage with a divorce and then for them to remarry. Also, I think the key is to be clean about it with immigration, not to hide it, because they're likely to figure it out sooner or later on. And there are waivers available if there was any fraud committed with immigration. You might as well get those waivers now when you've cleaned up the case. So yes, for somebody who has multiple marriages and may have forgotten to get divorced in between, it is difficult but possible to rectify that situation for purposes of applying for an immigrant visa.
There are instances that when a person marries someone and then here in USA and then files a divorce, and while the proceedings are in the court and goes back to India and does a religious marriage but not a court marriage, which he does after the divorce is done, can he still bring the wife?
That is really a complicated question, and the first issue with that is, will immigration recognize the religious marriage?
Correct.
And that's often a fight with immigration, whether or not they would recognize it. And sometimes immigration wants to recognize it to hurt the petition, and sometimes they don't want to recognize it when it benefits the petition. Of course, immigration can't have it both ways. So it is a complicated circumstance, but it can be rectified. The key in all of these cases is to come back to the beginning, clean up the mistakes, and then redo it.
Yeah, so in a situation like that, once the divorce is legal, go ahead and make that religious ceremony a valid civil ceremony. And once it's a civil marriage, then the petition can take place, and then you could start petitioning. They wouldn't have a problem with petitioning for that spouse, provided they did not marry the spouse civilly prior to the divorce. The divorce has to have taken place before the civil marriage, not necessarily the religious marriage. Immigration does view them quite differently. Religious marriage is not a marriage at all in the eyes of CIS.
But in India, they recognize religious marriage as a real marriage, and so this law doesn't come in conflict with the Indian law?
Well, they may be married in India, but as far as the United States and most other countries, they wouldn't recognize it if they don't follow the same rules as India. In this case, the United States only recognizes civil marriages, so it has to be recorded with the civil authority, and a religious marriage is not recorded necessarily. If it's both religious and recorded in the civil authority, then it is recognized in the United States. So what they would need to do is just go ahead and get it a civil marriage, and then they can continue with the application process.
Okay, Ms. Bretz, you deal with the employment-based cases. Is
I
it
do.
possible for if somebody is on H4 visa and he files for H1 converts, and before the petition is approved, he leaves the country, he or she leaves the country and comes back on H4 when the H1B has already been approved, how he can come back and can he still work? Because when he comes at the airport, the stamp will be H4, but when the approval took place, she was an H4.
Okay, well, that's interesting. If they returned to the United States before they were legally able to start work, which normally would be, let's say, October 1st, because that's the new fiscal year. If they returned back to the United States in the beginning of September, they're going to come back on that H4 visa, and they would still have their approval notice for October 1st to start the job. Now, while they have an approved H1B and they could work in the United States on that, if they wanted to travel, they will need to make an appointment at their consulate to get a new visa in their passport that would then reflect their current visa as an H1B. So they wouldn't be able to travel internationally on that H4 anymore. They should not, even though immigration might let them. Once they have started their job and they travel outside the United States, they should get a new visa that indicates their current status as an H1B holder.
I have a similar question, actually, another scenario where H4, one is holding H4, H1B is approved here in the USA, and the company asks the employee to go and work in Germany, say in Germany for 2 months. The employee goes to the Germany and works there for 1 month, and she could not get time to get the visa stamped for H1B and returns back to the country on H4. Can he work on H1B?
As long as he starts working after he enters the United States as an H4, he's still under the H4 status until the work starts on his H1B. He might have been approved for it, but it doesn't start until the actual employment date starts on the H1B.
No,
So,
the question is that he's already working on H1B.
oh, he's already working on the H1B.
Yeah.
He really needs to, immigration can't grant his visa in the United States. He has to go to a consulate office to change the visa to be in the correct visa.
So if he comes back and he's admitted on the H4, he really needs to leave the U.S. again and go to a consulate to get an H1B endorsement in the passport. Is that
To have
correct?
the visa in his passport. But he probably has the approval notice that says he has valid H1B status.
Yes.
Yes.
That's an interesting case. Is that one of our cases, Manjeet?
No, it is not one of our questions. I have another case scenario where a person whose green card is pending here, he goes back to his country on H1B visa and comes back on B2 visa. Will that green card still continue? Can
Well,
he still get the green card?
he would have had to get advance parole on that green card application. So while he was in his H1B status, he obviously had someone petition for him. And in
Yeah,
this
he
case, I
has
don't
he
know.
has advance parole also.
Okay, so if he
But he
has
traveled on B2 visa.
when he
business
got
trip.
advance parole, he advised the immigration that I'm going to be traveling. So he didn't abandon his green card application. However, he did return in the wrong status.
Yeah.
They will probably still adjust him at the interview, but really he could have some problems with the immigration officer depending on who's going to review that adjustment of status case, because they're going to recognize he wasn't paroled in, he was admitted, and they could cause some problems. But that really depends on the examiner at that time.
ਛੋਟੀ ਜਿਹੀ ਬ੍ਰੇਕ ਲੈਂਦੇ ਆ ਤੇ ਮੈਂ ਤੁਹਾਡੇ ਕੋਲ ਫਿਰ ਵਾਪਸ ਆਉਂਦਾ। ਤੁਸੀਂ ਇੱਥੇ ਹੀ ਰਹਿਣਾ ਤੇ ਹੁਣੇ ਤੁਹਾਨੂੰ ਮੈਂ ਕੈਰੀ ਬ੍ਰੈਡਸ ਔਰ ਐਲੀਨ ਬ੍ਰੈਡਸ ਦੇ ਨਾਲ ਗੱਲ ਕਰਾਵਾਂਗਾ। ਹਾਂ, ਸਤਿ ਸ੍ਰੀ ਅਕਾਲ ਜੀ, ਮੈਂ ਜਸ ਪੰਜਾਬੀ ਤੋਂ ਬੋਲ ਰਿਹਾ ਤੇ ਕੈਰੀ ਬ੍ਰੈਡਸ ਔਰ ਐਲੀਨ ਬ੍ਰੈਡਸ ਮੇਰੇ ਸਾਹਮਣੇ ਹੈਗੇ ਤੇ ਅਸੀਂ ਉਹੀ ਸੈਗਮੈਂਟ ਤੇ ਸ਼ੁਰੂ ਕਰ ਰਹੇ ਹਾਂ, ਅੱਗੇ ਕੰਟੀਨਿਊ ਕਰ ਰਹੇ ਹਾਂ। ਤੇ ਮੈਂ ਹੁਣ ਕੁਐਸਚਨ ਕਰਾਂਗਾ ਕੈਰੀ ਬ੍ਰੈਡਸ ਨੂੰ। ਮਿਸਟਰ ਕੈਰੀ, when a person comes on C1 visa but he flies, he doesn't come by ship but he flies to USA to take join a duty in a crew on the ship. Can he, if he doesn't go and marries someone here, can he adjust his status here in the USA?
Yeah, that's an excellent question. Most people believe that if you're a crewman, you're barred from adjusting your status after you overstay your visa. And that's actually partially correct and partially incorrect. There are two classes of visas in which crewmen have. One is a C1, and the other is a D1. A D is somebody coming off a ship. A crewman coming off a ship, unfortunately, are barred from getting many immigration benefits, including if they marry a citizen of the United States to apply for adjustment of status. But a C1 is a crewman who flew to the U.S. to then go pick up a ship. They're normally admitted for 5 days or 10 days. It gives them enough time to get from the airport to wherever the ship may be located. This happens a lot in Miami, sometimes in New York. But C1s can adjust their status. And I'm surprised at how many cases we've done in the office where actually Citizenship and Immigration Service didn't even know that. They went somewhere else, they applied, and CIS denied the case. And when they came to us, we had to explain to CIS by looking at the regulations that they were incorrect. So yes, a C1, a crewman coming off a plane may adjust their status. A D1, unfortunately, a crewman coming off a ship cannot.
I have now another question actually about immigration new regulations that were about to come when Senate approved it, but Congress didn't approve it. So what is going on? Do you think it is still possible that Congress is going to approve it?
Well, that's a great question. With the government being shut down now, we don't really know, do we? Earlier in the year, the Senate did pass comprehensive immigration reform, which had a lot of really good things. If you were physically in the U.S. as of December 2011 and you didn't have certain criminal history, you would be entitled to get a work authorization and travel permission. And that would be good for up to about 10 years, and then later on be able to apply for a green card. There was a FASTA category for people if they were what they call dreamers, children who came here before they were 15 or 16, went to high school here. They would be able to get the same benefit but be able to get their green card in 5 years. The Senate passed this. There was some rough things in the bill too. There was a lot of enforcement issues, more penalties for immigration fraud, greater penalties. But it was a good start, and it's really been stalled in Congress. We don't know now with the government shutdown, but only last week, even with the government shutdown, there were a group of Democrats who put forth or made an effort to put forth an immigration bill. So I think there are some people trying to keep it alive. I hope it does pass. If it doesn't pass this year or early next year, too close to the midterm elections, it's not likely to pass. In the meantime, Obama did some things himself through the executive power and prosecutorial discretion powers, where he has allowed children, known as childhood arrivals, deferred action for childhood arrivals, or DACA, to be able to get work authorization. And with work authorization, they can also get driver's license and some other benefits. And to be eligible for that, you had to enter the U.S. before you were 16 years old, and you couldn't be more than 31 as of June last year, June 2012, and you can't have a certain criminal history. So that was one thing Obama did. Another thing he did was the provisional waiver. Normally, and I think Eileen really is an expert on this, normally if you enter the U.S. illegally and you marry a citizen, you would have to leave the U.S. The day you leave, you'd have a 10-year bar before you could come back. There's a waiver of that 10-year bar, but you would be waiting back home in India for 2 or 3 years to see if that waiver would come through. So Obama passed a regulation in March that Eileen can explain that allows people to do the waiver in the U.S.
Yeah, he passed something called the provisional waiver. Provisional waivers are only available to immediate relatives. Immediate relative, term of art for immigration, it means either the parent of a U.S. citizen over 21 or the spouse of a U.S. citizen. In those two scenarios, if you have a petition that's been approved and the only thing barring you from adjusting is the fact that you entered illegally, you can get a provisional waiver. The waiver has to be completed on the U.S. side with CIS. If it's approved, it gets forwarded to the consulate, and you go to a consulate for your interview, but you could be back within a week or two from leaving the country. The provisional waivers, they've been, I would have to say, they've been pretty fair on adjudicating those, and most of them are getting approved. So it's a good It's a good path for those that have unlawful presence and they have no other way of changing their status in the United States. It allows them to stay in the United States while the application is pending, and if by chance it is denied, you just don't leave the country and you're in no worse situation than you were before you started the process.
I think, Manjeet, if we don't get comprehensive immigration reform, I think the Obama administration will continue to do little fixes like this for different groups. There'll constantly be more discretion being applied. And in fact, there is a lot of discretion being applied. In the deportation end, although they're deporting record numbers of people, over 400,000 people a year, they're not deporting, for the most part, people without a history of fraud or criminality. The people that they're deporting are sexual predators, gang members, drug traffickers, fraudsters, and way down on the lowest priority are elderly people, children, family people. We have so many clients that have orders of deportation that immigration is not executing. They're allowing them to stay either through a stay of deportation, deferred action, or an order of supervision. And many of those people are also eligible for a work authorization. So in the absence of good comprehensive immigration reform from Congress, the Obama administration and the Department of Homeland Security have been using their discretionary powers to enforce the law only against certain categories of people, which I think is smart.
Do you think, Mr. Kerry, that this comprehensive bill will cover all those who are felons or misdemeanors? They will also get the green card, or those who have multiple deportation exclusion orders?
Great question. In terms of the criminal end, we already know the answer to that. If you were convicted of any felony, if you were convicted of 3 misdemeanors, and if you were convicted of something called a particularly serious crime, you're not going to be eligible for any immigration reform. If, on the other hand, you have a deportation order for some other reason, the likelihood is you will be eligible. You may need to file something extra. You may need to do something more than everybody else, but you'll probably be eligible.
Yeah, like in different names, somebody has applied previously asylum, and they have different names, deportation orders and exclusion orders.
Chances are those folks will be eligible. We don't know for sure, but they probably will be. They just may need to file something extra. But on the criminal end, 1 felony, 3 misdemeanors, you'll be out.
Okay, another scenario is that if a person comes here on green card, one person has a green card and the airport, they stop him, they say 20 years back there was an exclusion order and you had that was not taken care of and you never mentioned about it, so you are still, you are not eligible for green card. They take away his green card, what he can do?
That's a great question, and it's interesting, this came up on one of the other shows that we did. The law actually, for someone who got their green card by fraud, forgot to mention a previous immigration case or some fact that might have made them ineligible, there is a waiver. It's called a 237A1H waiver, and it just requires a parent, spouse, or a child in your family. You need not even show hardship to them. It's a discretionary application. But if you're lucky enough to live in the 3rd Circuit Court of Appeals, which covers New Jersey and Pennsylvania, and it is more than 5 years after you got your green card, guess what? The court said immigration can't place you in deportation proceedings. So I have some clients in this circumstance, and when they learned that the law was different in other places, they are contemplating moving.
Yes, I have similar question. If somebody has that and they take away the car and that guy moves immediately to New Jersey, can he still save his green card?
Well, maybe. Immigration, believe it or not, has the right, ICE has the right to begin a deportation case or a removal case where it deems fit, not necessarily where you live. So if this case was started in New York and you moved to New Jersey, there's no guarantee that an immigration judge would transfer the case from New York to New Jersey, especially if the judge thought you were doing it solely to avoid the immigration consequences of the previous fraud. If your job moved there and you went there, that makes a lot of sense. If your children are going to school there, it makes a lot of sense. But if everything's still happening in New York and you just happen to have an address in New Jersey, it's probably not going to be a wise idea or work.
Suppose that person who is now in, you say he can be his green card can be still saved under section 237, he will have to again file for the adjustment of status?
No. The one nice thing about 237A1H waivers is that if you win it, you actually have kept your green card from the first day you got it, and most of those people who do win it immediately apply for naturalization. So it goes back to that first date. And I'm hoping before we run out of time that we get a chance to talk about investor visas.
Yes, Ms. Bretz, do you think one can file with just somebody's money an investment visa?
Well, and
People come here and they don't have money, and suppose they take it from somebody. Do you think it is still possible?
Well, the immigration has set up the investor visa specifically for people who can afford it. So they want to get the money from the person who actually has the ability to put either $1 million or $500,000 into an investment in the United States. If the person that's looking for the visa does not have the money, they can be gifted the money. But there are circumstances in when they try to borrow the money that might render them ineligible for the investor visa.
Can they take a loan?
They can.
Partial loan from and then invest it?
Well, the
Loan
problem
from the bank?
with the loan from the bank is that then they're still liable for that. So it wasn't their money that they're investing, and immigration will look at that as it wasn't their funds that they invested. So there are certain loans, maybe non-interest loans from family members, maybe it's a gift from a family member, but a loan from the bank usually does not qualify. But we'd have to look at it on a case-by-case basis, because there are things that can be done to help an individual figure out how they can invest in an investor visa, whether it be in the regional center or direct investment.
I have a question with that, if you don't mind, because it comes up and I'm curious. What if you're a wealthy Indian American, you have a family member, a niece in India, you have the money, it's domestic money from the US, but you want to give it to her so that she can come here and be a partner in your business or open up a new business where they would invest $1 million. Is that possible?
It's possible. It's not what immigration looks for, and a lot of people don't think it's possible because they want to see the money transacting from the investor, and the investor is usually abroad, and they want to see the path of the money. The big question here is, where is the source of the funds coming from? But if they are being gifted it from a wealthy relative or just, you know, a sugar daddy, then they could get it potentially from the United States, and it doesn't have to go from the United States to their home country back to the U.S. They would be able to get the gift here in the U.S. It's just a little bit more difficult because they obviously don't have bank accounts in the United States. They don't have any place to receive the money, but there are ways in which they can receive the money in the United States in their name.
And if I have another question in investment visa, if somebody it is in partnership and the other partner doesn't claim for green card, still one can do it?
They can only use the money from a couple, a married couple, to invest in that, where it would be one party's money, but they cannot have a partnership with a friend or a neighbor and then use that full amount of money for this investment visa.
ਅਸੀਂ ਇੱਥੇ ਹੀ ਖਤਮ ਕਰਦੇ ਹਾਂ ਸੈਗਮੈਂਟ, ਕਿਉਂਕਿ ਸਾਡਾ ਟਾਈਮ ਖਤਮ ਹੋ ਰਿਹਾ ਹੈ, ਤੇ ਮੈਂ ਉਮੀਦ ਕਰਾਂਗਾ ਕਿ ਤੁਹਾਨੂੰ ਇਹ ਕਈ ਤੁਹਾਡੇ ਜਿਹੜੇ ਮਸਲੇ ਨੇ ਇਮੀਗ੍ਰੇਸ਼ਨ ਦੇ, ਉਹ ਤੁਹਾਡੇ ਸਾਹਮਣੇ ਜਿਹੜੇ ਇਹਨਾਂ ਦੇ ਜਵਾਬ ਤੁਹਾਨੂੰ ਮਿਲੇ ਨੇ, ਇਹ ਤੁਹਾਨੂੰ ਹੈਲਪਫੁਲ ਹੋਣਗੇ, ਤੇ ਤੁਸੀਂ ਸਾਨੂੰ ਕੰਟੈਕਟ ਕਰੋ ਕੈਰੀ ਬ੍ਰੈਡਸ ਨੂੰ ਔਰ ਐਲਿਨ ਬ੍ਰੈਡਸ ਨੂੰ, ਬ੍ਰੈਡਸ ਐਂਡ ਲਾਅ 305 ਬ੍ਰੌਡਵੇ, ਤੇ ਤੁਸੀਂ ਉੱਥੇ ਆ ਕੇ ਆਪਣੇ ਜਿਹੜੇ ਨੇ ਸਮੱਸਿਆਵਾਂ ਦਾ ਹੱਲ ਲੈ ਸਕਦੇ ਹੋ। ਤੇ